morning, Your Honor. I will be pleading non-guilty today, and I will be representing.
Whoa, hold up. This defendant just told the judge he's representing himself. That's a bold move, and usually a very risky one. Would you ever walk into court without a lawyer? Let me know in the comments.
Representing myself.
Okay, there's a certain way we go through things. Just bear with me a second. So the first thing is that you're charged with failure to stop and give information. You're facing up to 6 months in jail and or 2,000. I know that you're ready to say, go through your list of this and that, but because you want to talk, you're not listening. I need you to listen for a second. I'll give you time to talk, I promise. Just let me get through the spiel and then I'll give you an opportunity, okay? You're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent.
Listen to this. The judge is laying out the classic Miranda-style rights. This part is so crucial because once a defendant talks too much, the DA can use every single word against him.
Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, we're just going to do probable cause because I don't know what happened. Maybe there's no probable cause and then you're out of here. I don't know. Stop. You have the right to remain silent. Exercise that. They're DAs. Every single thing you say, they're going to sit there and type to use you.
I know that's my right.
Just hold on. Let's do probable cause first. Okay.
Yes, Judge. On June 15th, 2024, officers were dispatched to a crash. They met with the complainant who reported that she was involved in a crash with a Toyota Tundra and provided the license plate number. The male with gray shorts, no shirt, and tattoos stepped out of his vehicle and offered the complainant to follow him back to his house, and the complainant declined the offer. The defendant then left the scene without giving any information and sideswiped the complainant's vehicle a second time. The officers began to head to the car's registered address, 0.4 miles away, when they received a second call for help at the address they were headed to.
Wow, that escalated fast. Not only did he leave the scene, but officers later find him having a full-on mental health episode at home. This is where criminal law and mental health collide. Tricky territory for any judge.
At the address, a male matching the description provided by the complainant was having a mental episode in front of his house. The defendant admitted to driving and leaving the scene without giving information. The damage was approximately $2,000.
Okay. All right, Mr. Peeler, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
So on June 15th, I was in a state of psychosis, and I had documentation of the settlement that took place for the liability property damage which occurred on that incident. I had the claim number in front of me if you need it, Your Honor, for that settlement. I have the mental health crisis documentation, discharge summary provided by the Harris.
Notice how the defendant is already talking about his mental health records and hospital discharge. This could actually play a role later, either as mitigation or as a way to show he wasn't fully in control during the crash.
County Constable living at 13800 Lake Superior Lane. If you need that, upon further request, I can provide documentation of the discharge from the hospital that I went to.
Let's do this.
Supporting the mental health.
Mr. Peeler.
And I'm disabled. So.
Let's do this. Why don't I have you talk to a lawyer? Okay. Your lawyer can talk with you, get to know you, find out what happened, and then they can approach the state to try to, see what's going on.
Because I'm disabled and I don't want to be, and I never was.
Just don't say anything.
Warrant at all. I never received anything in the mail, not once. So how can
sometimes cases work like that. Sometimes a person is involved in some kind of situation where a warrant will not issue immediately to where they get taken into custody at that time.
Well,
those are called
in the mail, so I assumed that I would have received something.
Never assume anything.
You're right.
Never assume anything. But let's do this. I can have you talk to a lawyer.
The judge just said it. Never assume anything with the legal system. Seriously, cases can sneak up on you. Ever been surprised by a letter in the mail you weren't expecting? Multiply that by 100 when it's a court notice.
We're here momentarily. You can explain your situation to the lawyer. The lawyers can talk to the DA, and then we can work something, okay?
So
just hold on.
I agree.
I don't want you to say anything because there are a bunch of DAs here, and everything you say, they're going to use it against you. I will give you the opportunity, but first let me have you talk to a lawyer. I've got a bunch of them, and they're great. They truly will help you out. Okay, really. Yeah. So let's do this. I'm going to have you go to Victoria, sign a reset. I'm just going to have you take a seat in the jury box while I find your lawyer. Be patient, though. I've got 150 people here, Mr. Peeler. Okay, so just be patient. Okay.
Failure to, well, I actually did stop. I mean, for the record, we both exchanged words outside our vehicle.
Okay, come on.
Proctor, Bessie,
Good morning, Ms. Stokes. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On October 31st, 2024, the officer was dispatched to a Walmart in Harris County, Texas, in regard to a theft. Upon arrival, the officer met with the complainant, the loss prevention staff, and the defendant. The complainant advised that she observed the defendant concealing items on her person along with skip scanning items at the register. The complainant then observed the defendant proceed to walk out of the store, passing all points of sale. Total cost was $49.92.
Stokes, I'm going to find that there's probable cause to go forward with the case. I'm barring you now, and I'm ordering you not to go to any Walmart for any reason. You understand? If I find that you go to Walmart and I don't care what your reason is, I'm going to put you in jail. You will not get any more PR bonds. You're already on.
Oof. The judge is coming down hard on this woman. No more Walmart, period. One slip up and she's straight to jail. That's what we call a zero tolerance condition in courtroom terms.
On bond for a felony theft as it is now. It's very possible they revoke your bond and issue a felony warrant for your arrest. What happened with the felony theft that she's on now?
Your Honor, on the felony theft, it says that the officers were on patrol and ran the vehicle through NCIC and noticed the vehicle was reported stolen. The traffic stop was conducted. The driver of the vehicle was identified as the defendant. The complainant identified herself as the sales manager of the auto dealership and stated the defendant came into her office to purchase the vehicle for $11,000. The complainant stated the defendant presented 3 money orders for $1,000 each as down payment. The complainant stated they only allowed the defendant to leave with, they allowed the defendant to leave with the vehicle. The complainant stated several days later she found out the money orders were stolen. The complainant contacted the defendant and told her to return the vehicle immediately, which were ignored.
And I see that she has yet another one from March of this year as well. Same thing.
Let me see, Your Honor. In that incident, she used stolen identifications and rented a car for 1 day and was supposed to return it, but failed to return the vehicle.
I'm ordering you not to drive. I'm making it a condition of your bond that you're not to drive. Do you understand? Do you have a Texas driver license?
Yes, sir. Yes, sir.
All right, Your Honor.
You know what? Let's do this. I'm going to appoint your lawyer today, ma'am, and then we'll talk about all your bond conditions. I'm going to have you sign a receipt of Victoria, and then I'm going to have you take a seat in the jury box, ma'am. Do not go away until we have you talk to the lawyer. Okay? Please.
Right this way. All right, Judge, next is page 19. Warzock, Emily.
Is it Miss Warzebach?
Warzock.
Ms. Warzebach, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On October 23rd, 2024, the officer was conducting surveillance at a department store in Harris County, Texas. The officer observed the defendant enter an Old Navy. The officer made contact with the complainant, the loss prevention manager, who stated the defendant entered the store, selected multiple pieces of clothing, and walked towards the front of the store. The defendant abandoned merchandise on the table, but kept a white sweater. The defendant passed all points of sale with the unpaid.
This is actually a powerful teaching moment. The judge is explaining how multiple convictions can ruin job opportunities for life. It's more than just punishment. It's about how society views you afterward. This case just took a darker turn. A cigarette burn in the middle of a domestic fight. And now, the judge is throwing in a protective order. That's how fast things can shift from argument to lifelong legal consequences.